Judicial Watch doesn't wait for an election to start talking about election security. We're working on it all year, every year, between elections, whether or not they're happening or not. I talked about Russ Noble. Congress called him the other day to talk about the election integrity measures that they are considering in the House. They passed the SAVED Act out of the House of Representatives this past week. There's another bill they're calling, I think, the mega bill, which even further strengthens election integrity measures. And I think Russ was asked specifically to talk about that in terms of making sure the rolls are clean and things that Judicial Watch is really quite expert and adept at. Russ was testifying on behalf of Judicial Watch, and you, if you're a Judicial Watch supporter or other patriotic American who wants the rule of law upheld and strengthened when it comes to election integrity. He just testified this week, and his presentation was excellent. I encourage you to go and watch it in its entirety, watch the entire hearing, the good and the bad, as far as I'm concerned, from the left especially. But here is Russ's opening statement to the House Administration Committee earlier this week.
The core point of my testimony is simple. Public confidence in integrity of elections is declining. The decline is not driven by lack of ballot access, but rather inadequate and lax enforcement of basic election integrity safeguards. The data tells a clear story. Voter registration and turnout continue to go higher, and minority ballot access is at or near record levels. Historical racial disparities supporting the need to promote ballot access have largely been eliminated. At the same time, the public strongly supports common sense election integrity measures. Large majorities support voter ID and uniform election deadlines. They support proof of citizenship requirements and clean registration lists. Yet despite this consensus, many states have moved to undermine election integrity. One of the most troubling shifts has been the expansion of universal mail voting, which sends unsolicited ballots automatically to all voters regardless of eligibility. My written testimony describes how progressive politicians proposed this very system 100 years ago. It was a bad idea then, it remains a bad idea. No mature democracy would adopt such an insecure voting system. Among other ills, it weakens chain of custody protections, it increases the risk of coercion, and brings that risk of coercion to people's houses, a real risk for vulnerable voters. It risks third-party interference and administrative error. It erodes public trust in elections. Universal mail voting is bad policy in any context, but it's particularly bad when combined with inaccurate voter registration lists. Not long ago, the Supreme Court found that 24 million registrations, about 1 in 8 in the United States, are invalid or inaccurate, and 2.75 million people were registered in multiple states. Dirty lists have long been the gateway for other election mischief. Take California, who Judicial Watch is suing right now on behalf of the Libertarian Party. It has both universal mail voting and dirty registration lists. Our own internal analysis found that 21 counties with approximately 6 million voters removed a combined 11 voters over 2 years for change of address. That's 11 voters removed from a group of 6 million, 11 over 2 years. The NVRA imposes modest list maintenance duties on states, and it guarantees organizations like Judicial Watch access to list maintenance records so we can verify compliance with federal law. Many states fail under both federal obligations. Many do not conduct meaningful list maintenance, and when we simply ask them for the records to verify, as we're allowed to under federal law, they refuse, delay, or claim the records do not exist. Now they're not even giving the records to the Department of Justice, where I formerly worked, and would ordinarily ask for these records from 2004 to 2010. Those refusals are not just technical oversights. They defeat transparency, they prevent public oversight, and undermine public confidence in the election administration. Last year, Judicial Watch reported that our enforcement efforts over the years have resulted in more than 5 million ineligible registrations being removed nationwide. 5 million. Despite our success, we've barely moved the needle. Just last month, Oregon's new Secretary of State announced that they needed to remove 800,000 inactive voters in response to our lawsuit. The evidence shows that Oregon hasn't removed voters since 2017. While Oregon's announcement is progress, it illustrates just how pervasive state noncompliance has become. We have other suits pending. Finally, I address the recent trends where states are allowing ballots to arrive days and weeks after Election Day. For the last 5 years, my colleagues and I have sued several states challenging this practice, and last month the Supreme Court ruled in our favor in the first case in which we represent Congressman Michael Boss in his suit against Illinois. It took 4 years to get a federal court to say that we could sue, and finally the Supreme Court agreed. The regressive practice of allowing ballots to roll in for days and weeks after Election Day is chiefly responsible for creating the banana republic-style confusion that follow American elections today. Judicial Watch's client, Libertarian Party of Mississippi, along with the RNC, successfully sued Mississippi in 2024 over this same practice. We won, and then yesterday we filed our brief with the Supreme Court to defend our win. The Supreme Court will hear that case on March 23rd. Our brief is attached in the record. 76% of the public support it. History explains why election integrity safeguards exist. They're not adopted by accident, and they're not racist. Thank you for inviting me to testify today.
That was a great presentation by Russ, wasn't it? I encourage you to share it with your markets, as I like to say, your friends, your family, coworkers, members of your church, etc. And then there's a series of questions that take place after the presentation by Russ and the other witnesses. And here's a sample of, I think, Congressman Mary Miller questioning Russ and highlighting Judicial Watch's important work.
Mr. Noble, first, I want to acknowledge and thank you and my Illinois colleague, Congressman Mike Boss, for fighting to secure the right of candidates to challenge state election laws in federal court. As you know, Illinois insists on the controversial practice of counting ballots received after Election Day, and I'm glad that Congressman Boss' challenge to that policy is moving forward on its merits. In regards to a related case, how does Watson versus RNC, currently before the Supreme Court, affect congressional efforts to ensure that ballots are received no later than Election Day?
There's been some, I guess the Supreme Court will settle the issue under current law if we prevail. Congress can obviously make new law and be more explicit in what it requires if it acts now. But this question, which arose in Boss first and now is in Watson, is what is the original public meaning of the 1845 statutes? What is Election Day?
Well, we're going to look forward to that. When it comes to voter roll maintenance, how do we ensure that states comply with the requirements set by MEGA Act when many are already non-compliant with the current NVRA statute?
Well, I think forced disclosures, which we try to do at Judicial Watch, and then frankly just follow up with suits. I mean, there's fertile ground and opportunity for us to sue over. Frankly, we shouldn't have to come to that, but obviously lawsuits help. And when we find when we find a jurisdiction in violation, it's usually not a close case. I mean, they're not sending out confirmation notices. They're not removing people. Mm-hmm. It's pretty slam dunk. But the partisanship nature of the question makes it very difficult to get anyone to just settle and resolve the questions.
Well, you can see that Judicial Watch has some excellent legal representation, as evidenced by Russ's remarks there. If you want to watch all of the hearing, I think we probably can link it below. I know it's on Judicial Watch's various channels, so feel free to follow up. But we're not backing down on elections. I mean, what happens is we get a lot of noise about election security around the time of elections. Judicial Watch doesn't wait for an election to start talking about election security. We're working on it all year, every year, between elections, whether or not they're happening or not. And that's why we're effective, because we just don't stop. There's no intermission when it comes to enforcing the rule of law. And we've had this big fight about the SAVE Act. Question is whether it's going to pass the Senate. I don't know. It probably won't. We just can't wait for election years to start talking about election integrity. I want the SAVE Act to pass personally. I want national voter ID. I want citizenship verification, but it should be front and center much earlier than now. And it's never too late. But on the other hand, politically, sometimes it can be too late in terms of getting things done. So this is the challenge, and the Judicial Watch rises to the challenge by doing the heavy lifting of election integrity enforcement all the time, as you can see from Russ's comprehensive report and testimony. Great work to Russ Noble and all the team at Judicial Watch. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.